So a couple of weeks ago, I was talking to a financial advisor on a Zoom call. Somehow we found my YouTube channel, and he was talking to me, and he was like, "I've been a financial advisor for a few years." And he said, "Paul, when I started my work as a financial advisor, I didn't even really know what a trust was. Had no idea." And so he said, "Paul, I watched a whole bunch of your videos, kind of was one of those binge watchers. And those videos really helped me kind of understand not only what a trust was, but why people use them and why they can be important and what all the benefits are." And he said it really helped me as I started working with my wealth management clients, really helped me kind of get a leg up and help solve some clients' problems. So that actually made me feel really good. I guess some of the stuff I've done has some benefit that I never hear about, never know about. So it's good to have a conversation. So that got me thinking, well, if that financial advisor didn't really understand what a trust was, maybe there's a few other folks who don't really understand the ins and outs of trust. So here we are today. Trust and estate planning, 12 areas of interest. Larry, good to have you back. Wasn't sure if something happened to you, but I figured you were away. Susie, we've got Mama Prangs, all good names there. Good to see everybody. All right, boy, I got a lot to cover, and I'm going to do it in a relatively short period of time. If you were thinking I was going to come on an hour later, originally I had to reschedule it. My son and his wife are coming over for dinner, and so I moved it up an hour. So, if you're watching it live, that's the reason for the reschedule of the beginning time. Okay, let's jump right in. I have 12 areas about trust that I want to cover. Let me tell you what they are real quick, then we'll jump in. Number 1, definition and purpose. Number 2, types of trust. Number 3, benefits of trust. Number 4, the trust creation process. Number 5, roles and responsibilities. Number 6, trust administration. Number 7, legal and tax implications. Number 8, costs and fees. Number 9, trust modification and termination. Number 10, common misconceptions. Number 11, practical scenarios. And then last but not least, I'm going to give you a few case studies and examples. So as always, feel free. The reason I do these live streams, some of you will watch this live. Many of you will watch the recording of it. And so when I ask you to throw some things in the chat, it's really for those of you live. If you're watching a recording, you can put interesting information in the comments if you'd like. Of course, we keep it all positive, constructive. But the way we kind of go through this, I'm going to go through my content that I feel like you'd want and need to know. Then we'll head over to the chat. Feel free to questions, comments, experiences, talk to each other in the chat. And I love this little bit of community aspect that we have doing this live stream and having the chat. Okay, let's jump right in. I really don't like talking about the definition of what a trust is. My preference is to tell you applications and give you case studies and tell you stories about people who had trust. But let's just start with the basics. What's the definition and purpose of a trust? So actually, if you look in our laws and our statutes where it defines what a trust is, it always talks about how a trust is a relationship, not necessarily an entity like a corporation or a LLC is, but a trust is really a relationship that a trustee has with beneficiaries. I know I'm giving you all these names. We'll talk about what everybody's role is, but essentially in layman's terms, a trustee looks after the assets while the beneficiary receives assets or distributions from the trust. That's maybe oversimplified, but trustee looks after the assets, beneficiary receives assets. So let me just start with an example. I want to start with an example. I think, geez, there's so many uses for trust. I want to make sure I start with the right example that encompasses all the things that I want to talk about. So let me just give you an example of, let's say there's 3 people involved here: senior, junior, and the third. So that's a grandfather, and then the grandfather's son, and then the grandfather's grandson, senior, junior, and the third. So one example of a trust, and I'll refer back to this example as I go through the different scenarios here. One example of trust is senior says, you know what, I'd like to write my will, and I want to leave $250,000 to my grandson, the third. Yes, he's leaving a big chunk to his son, but wants to carve out $250,000 for the grandson. But the grandson is 2 years old. That's the third. And so it doesn't make sense for the grandson to say, I'm going to leave my 2-year-old grandson $250,000. There's just a lot of red tape that would be associated with that. A 2-year-old can't open an account. If assets are left to a 2-year-old, then when grandpa dies, there's going to be a court proceeding, a guardianship proceeding, where a court has to appoint someone to be the guardian of the 2-year-old grandchild. And then the guardian manages that money under court supervision until the grandchild reaches the age of majority. Let's call that 18. And then it gets dumped into the grandchild's lap when he's 18. So we want to eliminate all those potential difficulties. So that's one of the reasons grandpa says, well, instead of just leaving it to the 2-year-old and causing all those difficulties and having the courts get involved and then having it dumped into my grandson's lap on my 18th birthday, I think what I should do, grandpa says, is I'm going to leave it the $250,000 to a trust for my grandson. And so grandpa then has to answer some questions. Number one, who's going to be the trustee of that trust? And grandpa says, well, my grandson's father. That's my son. My grandson's father, Junior, will be the trustee of that trust when I die. Again, this is in grandpa's will. So his will says a bunch of things, but one of the things grandpa's will says is when I die, I leave $250,000 to my grandson, but I leave it in a trust and I name my son Junior as the trustee of that trust. Says more than that though. So now we've established grandpa in his will is leaving $250,000 to the third, his grandson, but it's going to be left in a trust. And we know so far that Junior, when grandpa dies, is going to be the trustee of that trust. Now we got to talk about under what circumstances can distributions be made after grandpa dies from this trust to or for the benefit of the third grandson. So I'd say the typical scenario, it can be set up a bunch of different ways, but the typical scenario might say after grandpa's death, the trustee, Junior, has the discretion to distribute trust income or principal to the third, to grandson, for grandson's health, education, maintenance, and support. I say that a lot. It's called the HEM standard, HEMS. So, because a lot of grandparents say, geez, if it's going to be in a trust, I don't want to be locked up in a trust. I want it to be used for my grandson's education. When he goes to college at age 18, that might cost $100,000 a year. And so I want to make sure those funds are available for my grandson's education. So by leaving things in trust for the third and providing in the trust instrument that the trustee has the discretion to use principal or income for the beneficiary's health, education, maintenance, and support, that authorizes the trustee, if he has to pay a $25,000 tuition bill, that authorizes the trustee to use part of those funds to pay the college expenses of the third grandson. And then there's a couple of other provisions that are important, many other provisions, but maybe one other provision I'll focus on now just in this example is, when does this whole trust thing end? Does it end when grandson graduates from college? When is this thing over with? Does it last for the grandson's lifetime? Well, the answer to that depends on how grandpa set it up. Maybe grandpa set it up so that he says in his will, he says, I leave $250,000 to a trust for my grandson when I die. It's called a testamentary trust. We covered that last night. A trust, the terms of which are part of grandpa's will. His will says I leave $250,000 to my grandson in a trust. I name my son as the trustee, and the trustee shall have the discretion to make distributions out of this trust to my grandson for my grandson's health, education, maintenance, and support. And when grandson reaches the age of whatever grandpa picks, when grandson reaches the age of, let's call it 25, then the whole trust arrangement terminates. And at that point, the trustee is required to turn over what's left to the grandson, distributes all of the remaining principal to the grandson. Grandpa put age 25. He could have put age 30. He could have put, let's give the remaining principal to the grandson in stages, at a third at 25, a third at 30, a third at 35. Could have left it up to the son's discretion, the trustee's discretion, to determine when to terminate the trust and transfer it over to the beneficiary. Could have said that trust would last for the lifetime of the grandson, but maybe at age 25, the grandson becomes the trustee and everything stays in that trust for the rest of the grandson's lifetime, but the grandson becomes trustee at 25. By leaving it in trust for the grandson's lifetime may make it more divorce proof because it's less likely that those assets would be commingled by the grandson with other assets grandson may have with a spouse, making it more divorce proof. So lots of options there on what grandpa should say as far as when this trust terminates. But that's our example I'm going to refer back to from time to time. Just repeating the quickie version, grandpa in his will set up a testamentary trust. The terms of that said, when grandpa dies, grandpa leaves $250,000 to his grandson in trust, named son as the trustee. Trustee can make distributions to or for son's health, education, maintenance, and support. And then when grandson turns the age of 25, the trust terminates and son, as the trustee, transfers everything that's left to grandson. Maybe there's only $100,000 left when grandson turns age 25 because he used a big chunk of it for his education or other living expenses or other expenses that the trustee deemed appropriate. Okay. So the main purpose of creating a trust, especially in this instance, was protecting the assets for another person, benefiting someone by making a gift or a bequest to them without dumping assets or dumping a bunch of money into someone's lap, perhaps when they're not ready to have it dumped into their lap. I talked in this example, just kind of an by the way, about how grandpa set up his will and left assets to a testamentary trust that's part of grandpa's last will and testament. Some people, and I'll refer to this probably a couple more times throughout this live stream, a couple of people will make a slight deviation of that. They'll set up their living trust, and then in their living trust, it says, or in grandpa's living trust, it says when grandpa dies, $250,000 will go into a subtrust of grandpa's living trust. So people who do this in their will, they create testamentary trusts. People who do this in their living trust create subtrusts, just terminology. Okay, so we're off and running now. Next, I want to go into a good segue into the different types of trusts. I've had the question a million times, Paul, what's the difference between a revocable trust and an irrevocable trust? So whenever I hear that question, I'm like, oh, brother, I could talk about this for hours. But I'm going to spare you, and I'm not going to talk about it for hours, but I'm probably going to talk about it for a couple of minutes. All right. So all trusts are either revocable trusts or they are irrevocable trusts. Also, as I'll get to in a minute, all trusts are either living trusts or testamentary trusts or living trust subtrusts. More on that later. But yes, there are differences of application between a revocable trust. I always say revocable starting with an R, and then irrevocable trust. Most people would say, well, why would anybody set up an irrevocable trust? That sounds really fixed. Sounds like you can't change it. Why can't every trust just be a revocable trust? Heck, if I set up a trust, I certainly would like the right to change it in the future if I felt my family circumstances and my life circumstances warrant it. Why in the heck would anybody want to set up a trust that couldn't be changed? Well, it's because that the benefit that you're trying to achieve requires that trust be irrevocable and that perhaps you have no control over that trust after you set it up. Let me give you a couple examples. Many people set up their revocable with an R, their revocable living trust. Overwhelming reason people do that is so that they can title things in a way so that when they die, the assets in that trust avoid the court and lawyer involved probate proceeding. But it's a revocable trust, and that's okay, and that's desired, and that works out great, and all those assets remain owned by the person who set up the trust and put their trust in it. It's still that person's assets for income tax purposes. It's still that person's assets if they get sued. So there's no tax benefits. There's no creditor protection benefits from putting your assets into a revocable with an R trust with the intent to avoid probate. That's the main benefit of that revocable trust is you stay in control of everything, but when you die, the survivors don't have to go through the court process called probate in order to have things transferred into their name. Other trusts, irrevocable trusts, kind of have to be irrevocable to get the kind of benefit that you're trying to get. So for example, in our example, once grandpa dies and $250,000 of grandpa's assets go into that trust for grandson, or number 3, as I call him, and son becomes the trustee when grandpa dies, that trust, once grandpa dies, becomes irrevocable. Nobody can change the terms of it. Now, there's some flexibility built into that trust. Son, as the trustee, has the discretion to make distributions to grandson for his health, education, maintenance, and support. So there's some flexibility built into it, but nobody can change the terms of it. If the trust says when the grandson reaches the age of 25, he gets the remaining trust assets, nobody can change the terms of that. Now, if, for example, it says the grandson gets the assets at the age of 25, however, if in the son's discretion, the son believes that the assets should remain in trust longer for the trustee, then perhaps those assets could remain in trust for beyond the grandson's 25th birthday. So all of the terms, this is where all the terms of the trust instrument can be so important. I'm probably going to get some questions in the chat today. Hey, Paul, thanks for the information. My grandfather set up a trust, and I think it's an irrevocable trust. And can I do this or can I do that? And my answer almost 100% of the time is, well, we have to look at the trust instrument and see what the trust instrument says the party's rights and obligations are. So I get a lot of questions without even seeing a trust instrument. Can a trustee do this? Can a beneficiary do that? Can the person who set up the trust change this or that? Or, what if the circumstances change? What can we do with this trust? All depends on the trust instrument. So that's why the creation of the trust becomes so important. So every trust is either revocable or irrevocable. And so revocable typically for probate avoidance purposes, but everything's still your assets for every purpose other than avoiding probate. Or the irrevocable trust, which all testamentary trusts that take effect when the person who wrote the will with the testamentary trust dies. Once that testator dies, those testamentary trusts are irrevocable. Or if someone has a living trust and in their living trust, they said that when they pass away, assets are to be transferred to one or more subtrusts, those subtrusts become irrevocable once the trust settlor dies. There's other reasons that I'll get into later why people create irrevocable trust, a bunch of reasons that I'll get into in just a bit. Now, and I mentioned when we're talking about number 2 types of trusts here, all trusts are living trusts, which people set up during their lifetime. The typical one is the revocable living trust to avoid probate, or they are testamentary trusts, trust name that the provisions of which are in somebody's last will and testament, or a living trust subtrust, a trust that doesn't take effect until the person who set up the living trust dies. Boy, that's been a mouthful, but I'm just kind of going over the different kinds of trusts and how they differ from each other. Okay, moving on, number 3. Benefits of trust. You might be thinking, are trusts really necessary? Sounds like a bunch of things that maybe lawyers do to just create complication. Are they really necessary? So at least as far as I go, we don't use trusts unless we need them to get some kind of benefit that a person or a couple or a family is trying to get. So let me go through some of the benefits of people creating trusts. One, I've already mentioned it, is avoiding probate. Really, really common. You can leave all of your assets in your name and provide for where they go when you die with your will. But if you have assets in your name when you die, whether you have a will or not, assets are going to be frozen. Your survivors have to come back to lawyers like me. We've got to go through a court process, get judges involved. Judges have to sign court orders ordering that things be transferred to the appropriate people that are named in the will. And so a lot of people perceive that probate process is expensive, time-consuming, and just an all-around hassle, and they perceive that because in many cases it is. In some cases it's not, but in many cases it is. So many people, in order to avoid that probate process, they set up their living trust and they transfer their assets to their living trust. The living trust document says they can do whatever they want to with the assets for the rest of their lifetime, no restrictions whatsoever. Then when the living trust creator, we call that person the settlor, dies, there is a successor trustee named in the trust instrument. And it's that person's job to follow the terms of the trust and make sure that the beneficiaries named in the trust receive the trust assets pursuant to the trust terms. So when someone does create a living trust and they transfer their assets to it, a good way to look at it is the trust really replaces the will. If you leave everything in your name, your will covers who gets your stuff when you die. If you create a trust and transfer assets to it, then when you die, your trust instrument determines who gets your stuff when you die and who that successor trustee is, who's going to settle the estate, kind of like when you have a will, you name an executor. Okay. So that's one of the benefits of setting up a revocable living trust, is to avoid probate. Another advantage is just maybe this applies to the grandpa bequeathing $250,000 to his grandson. Another benefit of trust, it's a way to either give or bequeath assets to another, but without dumping assets into their lap. Perfect example: grandpa wants to bequeath $250,000 to his grandson who's 2 years old, but he doesn't want to dump it in the 2-year-old's lap, or even set up an arrangement where once on the grandchild's 18th birthday, they could get it. That might be a disincentive for the grandchild to go to college. So as we talked about earlier, grandpa sets up a trust, names son as the trustee, the third as the beneficiary, and son, who's responsible, manages all of that, and then makes distributions to or for the grandchild while the grandchild's young. And then in our example, grandpa said when grandson is 25, trust terminates and assets get dispersed to the grandchild. Okay. So that's another benefit of living trust, way to give or bequeath assets to another, but not dump it in their lap. Another one is people use trust to remove assets from their estate while they're alive to avoid the 40% federal estate tax. Not a concern to a whole lot of people. We do have a federal estate tax for people who die in 2024. The first $13.61 million of assets are exempt from the federal estate tax. So when somebody dies, you add up the value, fair market value of everything that they own, their house, their investments, their IRAs, their Roth IRAs, their brokerage accounts, their bank accounts, their cars, their businesses. If it's more than $13.61 million, you've got an estate tax issue. In fact, with married couples, each spouse has a $13.61 million exemption. So for married couples, that's $27.2 million. That exemption is scheduled to be cut in half for people who pass away in 2026 and beyond. There's going to be some inflation adjustment stuff, but in 2026, it's scheduled to be around $7 million exemption, which means if it is $7 million for married couples, it's $14 million, still excluding many families from having to worry about estate tax issues. But nonetheless, when it does apply, many people will transfer assets from their estate to an irrevocable trust, often for the children, for the grandchildren. And what that does, yes, they could just give away assets to the children and grandchildren to get assets out of their estate, but often they want to have some control over those assets after they're given away. So they put those assets in a trust, name someone as the trustee. That trust is for the benefit of all of the children or all of the grandchildren or perhaps even the great-grandchildren. There are limits that gifting limits a person in 2024 to they can give $18,000 as many people as they want to every year. If they give more than $18,000 to someone, they start using up some of their $13.61 million exemption, and they have to report those gifts on an IRS Form 709 gift tax return. So you see a lot of people out there, especially who are concerned about the upcoming sunset of the Tax Cuts and Jobs Act. The sunset will take place on January 1, 2026, when the exemption gets cut in half. We're seeing a lot of people starting to do some of this gifting, and they don't want to just, if they have grandchildren or great-grandchildren, again, who are 2 years old, they don't want to just give those people $18,000. They want to put it in a trust for them, make sure that those young beneficiaries don't get their hands on their money until they're older and more mature and have their education and all that stuff. So a lot of people gift assets from their estate into trusts. And again, those are irrevocable trusts. The IRS says, boy, if you're going to remove those assets from your estate, they need to go into a type of trust where you can't get those assets back. If you have the right to get those assets back once you put them into a trust for your child or grandchild, then they're really not out of your estate, and we're going to assess that 40% estate tax on those assets as well. So that trust better be an irrevocable trust. You can't get it back. So again, another use for the irrevocable trust in those circumstances. Okay, and then another reason or another benefit of using trusts is we don't do a whole lot of this work. I have in the past, especially in the state where I was originally licensed in Louisiana, but a lot of people who, let's just say someone has a modest home worth a couple of $100,000, and they have maybe another $200,000 or $300,000 or $400,000 of life savings, and they're getting to a point where they realize they're not getting any younger, and maybe they've even seen some family members go into a nursing home. Some people will, in order to attempt to preserve those assets and qualify for their state's long-term care Medicaid program, they'll transfer assets into a particular type of irrevocable trust. And in an ideal situation, they would have done that at least 5 years before they enter a nursing home. And so when they enter a nursing home, or when they enter a nursing home, they will have less than $2,000 of what's called countable resources that they own. And they will not have made any transfers to others or to trusts within the previous 5 years. And then that way, those assets are kind of looked at as protected, and the government or long-term care Medicaid program covers that nursing home expense within the Medicaid rules. So that's just another benefit or reason people establish trusts. Another common reason, and often this is a subtrust in people's living trust. Married couple might set up the Fred and Wilma Flintstone Revocable Living Trust. They have one daughter, Pebbles, who's 25 years old and been in and out of a couple of relationships, but hasn't been married yet, or maybe has been married and is now divorced. And Fred and Wilma are saying, boy, we have $3 million. And of course, we're going to leave it to Pebbles. Pebbles is our only child, but we certainly don't want Pebbles' inheritance to be lost, or we certainly don't want half of it to be lost if Pebbles later gets divorced. So what we're going to do is we're going to leave Pebbles' inheritance to the Pebbles Inheritance Trust, is what I call it. And so all of that inheritance that Pebbles gets from Fred and Wilma, it goes into the Pebbles Trust, and it doesn't get mixed up with other assets Pebbles may have with a spouse. So if Pebbles does later get divorced, she keeps her trust, and then Pebbles and the spouse split other things that Pebbles and the spouse may have acquired during their lifetime. So a lot of parents, this is really, really common. A lot of parents like it just because there's a lot of divorce around, and parents really like the idea of making their children's inheritance divorce proof. So another benefit there. Okay. Next, let's talk about how does a trust get created? All right. So especially in today's days of technology, if I'm going to have a thorough discussion about how trust created, let me start with, traditionally and still typically, today, how it's done. It's typically done by lawyers drafting trusts. Perhaps you may want to talk to me about setting up a trust. And this is not a sales job for me, but in the YouTube description, sometimes I get asked about it in the live chat. You can click on a link and fill out a short questionnaire and request a meeting with me. I own an estate planning kind of boutique law firm. We have people around the country with myself and our co-counsel network. So anyway, it's typically done by attorneys, especially trusts, because trusts have to be customized and crafted, and there's so many different pieces to it, and people have so many different desires about the terms that they would want inserted into their trust. So you have a conversation with me or somebody like me, and there's conversations like the initial part of the conversation should be, hey, what do you want to accomplish? Not, let's talk about your trust. And if it gets determined that an estate planning goal of someone, well, in order to accomplish that goal, a trust is required, then we have the trust conversation. And someone might tell me, Paul, my mother died, the probate took 19 months, and the lawyer messed all kind of things up, and we had to do a bunch of court filings. There was all these delays. So we like to set up a trust to avoid probate. And then, of course, the lawyer asks all the questions that they need to ask so that the terms of that trust are exactly what you'd want. Who's going to be the beneficiaries of your trust? Who's going to be the trustee of your trust? If any of the beneficiaries predecease you, where do you want their share to go? So are you going to leave things outright to people, or are we going to set up sub-trusts within your living trusts for a variety of reasons? So all those conversations you need to have. Or as in our example, if Grandpa came to me and he said, Mr. Rabelais, I want to write a will, and the most important thing to me, I have my net worth is about $5 million, and I'm going to leave the bulk of it to my kids, but I sure do want to leave $250,000 to my grandson. Or maybe he says I want to leave $250,000 to all of my grandchildren. Maybe he has 3, for example. And so in his will, we may set up a trust for that grandson, and so we go through all the terms of that, and who's going to be the trustee, and how long will the trust last, and under what circumstances can a trustee make distributions of trust income or trust principal to or for the benefit of that beneficiary. So how it gets created is usually it's a very important conversation, usually with lawyers who get these, who then have the job to craft that trust and then go over that trust and review that trust and make sure it accomplishes 100% of what you're trying to accomplish. So that's generally the process. Of course, there's a signature component. I don't know that it hasn't ever happened, but the way the various 50 states trust creation laws are established, I've never seen a trust created electronically by electronic signature is really what I'm getting at. Just estate planning law is behind the times when it comes to technology. Yes, I know many of you can go on your online and change your IRA beneficiary with the click of a button. Can't do that with a trust. It's all kind of hard paper and wet signatures, and many times trusts have to be notarized and witnessed, and there's all kinds of form requirements that must be met. It's just part of the trust creation process, and it is what it is. Okay, so now that we've talked about creating a process, let's talk about what everybody's roles and responsibilities are. First, let's talk about the trustee, what their role is. And I mentioned earlier, their job is to manage the trust assets. In the example, Grandpa, in his will, said, I leave $250,000 to my grandson in a trust. My son will be the trustee. Well, now the son is the trustee. So when Grandpa dies, they're going, if this was in Grandpa's will, for example, they're going to go through a probate process, and maybe son is also the executor of Grandpa's will. So maybe he's named to have a couple of roles here. He's the executor of Grandpa's will, who's in charge of making sure Grandpa's estate gets settled properly. And son is the trustee of the testamentary trust where Grandpa left $250,000 to grandson in trust and named son as the trustee. So what's son's role here as the trustee? Well, assuming that the $250,000 of assets, consists of money that comes from Grandpa's bank account or Grandpa's brokerage account, those assets are likely, son as the trustee is likely going to set up one or more accounts. Maybe it's at a bank. Son sets up a $250,000 trust checking account, or they sets up a trust checking account and a trust savings account. But if grandson is 2 years old and it's $250,000, and investing those funds would be appropriate and prudent by son, because $250,000 when grandson is 2 years old, that could be turned into $500,000, maybe $1 million by the time grandson is 25. So I envision in this circumstance, what son would do as the trustee is he would go open up a trust account at let's call it a brokerage firm. Might be Fidelity, Schwab, Vanguard, Edward Jones. Son gets to pick where those assets are held. So son, here's the distinction here. In our circumstance, and let's say he picked Vanguard. In our circumstance, son is the trustee. So this account will be titled Junior as trustee of this trust for the third, which is the grandson. And so there's a real distinction. I think a lot of people don't get it, and they get concerned about fees, and they're like, oh, well, geez, if you're going to have that trust account at Vanguard, there's going to be all kinds of trust fees involved. And that's just not necessarily the case, because we have an example here where son is the trustee and he opens the trust account at Vanguard. That's very different from grandpa in his will leaving $250,000 to his grandson in a trust and naming Vanguard National Trust Company as the trustee. Now there you are going to incur trustee fees of that a corporate trustee will charge, and all that's okay. They earn their fees, but that's not what we're talking about here. So there are no fees when when you think of trustee fees and corporate trustees and all those excessive fees that kind of make your spine tingle. That doesn't apply when there's an individual trustee who sets up the trust account, of course, at a brokerage firm. So that's what we have here. Son's the trustee. He goes and sets up the trust account at the brokerage firm, and of course, he's the trustee, and the assets are held at Vanguard. All right, so moving on. So that's the trustee's job. And so part of the son's job, he'll select how the investments are going to be. He'll select the investments, stocks, bonds, mutual funds, exchange traded funds, whatever the case may be. Trust might own a piece of rental property, but it's all the trustee who makes all those investment decisions. Yes, in some unique trusts, you have an investment trustee, a distribution trustee. We're keeping it simple here. Son just has trustee power, so son is making those decisions there, and he'll make the decision whether it's invested in assets that are likely to appreciate, growth type assets, or assets that produce income. So again, trustee's job to do all of that. What's the beneficiary's roles and responsibilities? Well, if I were going to be a party to a trust, I think I'd want to be the beneficiary. Beneficiary just kind of kicks back and maybe keeps an eye on the trustee, but beneficiary often just kicks back and takes in those trust distributions. Pretty nice gig if you can get it. So a beneficiary, they're entitled to distributions, all based on the terms of the trust instrument. Here again, I haven't gone to the chat yet, but I may get a chat. My grandmother died 30 years ago, and I haven't received any distributions from the trust she left me. Should I be getting distributions? Let's look to the trust instrument. And then maybe the next question is, well, my brother, who's the trustee, he won't give me a copy of the trust instrument. And then my response is, well, you're entitled, unless something's really crazy, you're entitled to a copy of the trust instrument. So let's make sure we get that first and then see what distributions you're entitled to. So beneficiary entitled to distributions. In our example, that 2-year-old grandson who's the beneficiary of a $250,000 trust that his grandfather set up in his testamentary trust. So, while the grandson's a minor, the grandson's not going to be doing much. But let's say the grandson reaches the age of 18 and he's like, I heard grandpa set up a trust for me when he died. I was 2 years old. And so I'd like some information. I'm an adult now. And so I'm a beneficiary of this trust. Dad, I need some information. I need to see the trust instrument. I need an accounting of trust income and expenses. So beneficiaries do have rights to information. I think a lot of people don't really understand that because they get in touch with me and say they're not getting any information. But my first response is, you're entitled to information. First, let's get a copy of the trust. Let's assert your rights to get a copy of the trust. And then 2, let's assert your rights to get the appropriate accountings and maybe even distributions that have been withheld from you. Okay, so it's that beneficiary's job, really, receive distributions. Sometimes, oftentimes a trustee has a discretion whether to make distributions. So you see some circumstances where beneficiaries, they really want to put their best foot forward and say, hey, trustee, I'm going to go to this particular school and you have the discretion to pay my educational expenses. I need a $27,000 check in the next 2 weeks to pay for my education. And that trustee often has discretion as to whether to make that payment or not. So sometimes the trustees will say, hey, beneficiary, with what you're asking me to do, I have the discretion whether to do it or not. And I'm going to exercise my discretion, and I'm not going to make that distribution because I don't think it's in your best interest to do that. So there can be some conflict between beneficiaries and trustees because the trustees hold the purse strings, but the trustee's job is to make sure the intent of the trust is followed. But there can be some conflict there. That's why a lot of parents who set up trusts, maybe parents have one child who substance abuse problems or can't handle money. They sense the need to put that child's inheritance in a trust so that child doesn't get it and blow it in one big chunk. But parents are reluctant to name the responsible child as the trustee for that irresponsible child because they often don't want that irresponsible child from badgering the responsible child / trustee into making distributions. So it's a tough situation out there for parents who have unique circumstances where one child's inheritance needs to be managed in a trust after the parents pass away. Those parents may be more likely to use a third party or a corporate trustee to handle that because they don't want to strain the relationship between the responsible child and the irresponsible child. Okay, so sometimes trustees need to be removed. I gave you a couple of examples where we get questions from beneficiaries from time to time. Hey, trustees not doing their job. Trustees supposed to be giving me information. They're not giving it to me. They're not giving me an accounting. What do I do? And in some cases, it's appropriate to have trustees removed because they're not doing the job that they're supposed to be doing. So when that happens, then that trusteeship falls to the next trustee in line who's named in the trust instrument. If there are backups, sometimes a court has to appoint a trustee in the event of a vacancy in the office of trustee because trustees either have been removed or have died or have resigned or just don't want to serve as trustee. Okay, let's move on. I don't know what number this is, but trust administration. How is a trust managed and administered? So typically, if a trust holds money or investment, stocks, bonds, mutual funds, trustee is going to set up an account. We talked about that earlier. They could set up an account at the financial institution of their choosing. If it's $20,000 or $30,000, they may just set up a trust savings account. And I'm using some very general examples here. If it's $250,000 or $500,000, very likely that the trustee is going to set up a trust brokerage account so that the funds can be invested, appreciate over time, and really benefit the beneficiary along the way. Those duties of the trustee, people ask me, and it's kind of a silly question. Paul, I'm the beneficiary of a trust. So-and-so is the trustee. They're holding $500,000. Can the trustee just do whatever they want? And I'm like, of course not. They have duties. So, some of those duties of a trustee, they must be prudent. They must carry out the terms of the trust. They have a duty of loyalty to the trust and the beneficiaries. They have a duty to give personal attention. Yes, they can hire professional help, attorneys and accountants, and they can delegate matters like that to others, but they typically can't delegate their matters of discretion, that discretion to make distributions for the health, education, maintenance, and support of a beneficiary. So trustees have that duty to give that personal attention. Trustees have a duty to account to the beneficiaries, trust receipts, trust expenditures. So lots of duties of a trustee. If you're presented with a designation of a trustee, if I were you, what I'd do is say, okay, let me see the trust instrument and see what it requires of me. Let me figure out who the beneficiaries are. Are any of these beneficiaries going to make my life a living hell? And if so, maybe I don't want to accept the position of the trustee. Or you might say, boy, what an honor to be a trustee. The person who appointed me as the trustee, they've passed away, but they talked to me about it. And I want to do everything within my power to honor the trust creator's wishes. So of course, I'm going to be the trustee, even though it's going to be a lot of work and I'm going to probably have to hire an accountant and account to the beneficiaries regularly. I'm going to be the best trustee I can be. So lots of rights though, and before you accept a position as trustee, it's not just, you may not want to make that automatic. You may want to kind of take a look at all the circumstances around being a trustee before you accept that position. How are beneficiaries' interests protected? Well, protected means a bunch of different things. So on one part of this is when Grandpa left $250,000 in trust for his grandson, and let's say grandson turns 18, gets a new car, and then goes out and causes a terrible wreck and injures people, and grandson gets sued. Well, if that trust had spendthrift provisions in it, which it probably did, because most lawyers, if not all lawyers, they put these spendthrift provisions in these trusts. There's no real reason not to. Then as long as those assets remain in the trust for that grandson, those assets can't be seized by the grandson's creditors. So son turns 18, he gets in a bad wreck, he gets sued, judgment for $5 million against grandson. That money is kind of tucked away in grandson's spendthrift trust, cannot be seized. Now, if the trust terminates and the money gets dumped into the grandson's lap when he's 25, then perhaps that judgment, he may have to cough it over then. And maybe another reason why inherited assets should remain in a beneficiary's trust for their lifetime. And then there's that whole decision of when a beneficiary can be their own trustee. So beneficiaries, it's generally better from a lawsuit perspective. I know most people don't get sued, but we all know that there's lots of lawyers out there ready to sue for just about anything. It is typically better to be a beneficiary of a spendthrift trust than to just have the inheritance dumped into your lap, at least from a creditor protection standpoint. All right, but beneficiaries have other rights where they can kind of protect themselves. They have the right to a copy of the trust instrument. They have the right to be kept informed. They have a right to accountings. In many cases, they have a right, at least annually, to an accounting of what the trustee did with the money. Okay, on January 1st, there was $273,000 of assets. What were the assets there on December 31st? And what in the meantime, in 2023, for example, I want to see all of the expenditures of the trust and all of the trust income. So that all gets looked at. All right. Next is, what are the legal and tax implications? Yes, you have to follow all the validity requirements when setting up a trust, have it all the right form, all the right words, notary, witnesses, lawyers are responsible for that. Let's talk about taxes for a minute. Here's also where a lot of people are misinformed. People think that all trusts pay way more tax than individuals pay. So first, I'm going to tell you what a lot of people are aware of, but then I'm going to get into it a little bit more, and you're going to say, oh, I get it now. So let's look at the stuff that appears on its face to be really scary. What appears on its face to be really scary, let's talk about a married couple with income. They work, they have an investment income. Yes, I think we have 7 different income tax rates. As many of you know, we have this graduated income tax rate structure. Starts around 10%, 15, goes on up. Top income tax rate is 37%. Married couples filing jointly hit that top 37% rate when their income exceeds $731,200. Well, trusts have the same 7 rates, 10, 15, but trusts hit the top 37% trust income tax rates when trusts have taxable income that exceeds $15,200. So it's better for a married couple to have taxable income than it is for a trust to have taxable income, because married couples can have up to $731,200 without going into the 37% rate, where a trust can only have $15,200 without going into the top 37% rate. Now, here's the deal. Many trusts, whether it's a revocable trust, which is considered a grantor trust, the trust income tax rates never apply. All those assets are, for income tax purposes, considered the assets of the person who created the trust. So all that individual, grandpa, if he set up his living trust, he'll report all of his revocable living trust income on his personal income tax return. When he sets up a trust account, he'll use his social security number, so the trust income tax rates never apply. Even after grandpa dies and there's this trust for the grandchild, if the trust income gets distributed to the beneficiary, to grandson, then the individual beneficiary reports that income on his personal return. The trust doesn't pay income tax. Only when trusts accumulate income, these irrevocable trusts accumulate income, do trusts have to report and pay the income tax. And then if that income is over 15,200, it'll be taxed at 37%. So all revocable trusts never get, while the trust settlor is alive, never are subject to the trust income tax rates. Irrevocable trusts, if the trust accumulates the income, will be subject to the trust income tax rates. Moving on, costs and fees. I can't speak for everybody, but I've been around the block long enough to know that if you're going to work with a lawyer and set up, one or more trusts, whether it's avoid probate, get stuff out of your estate, move things out of your name for Medicaid purposes, give assets to young people to during your lifetime, but want it to be held in trust. Very general statement, but probably looking at a few $1,000s. I'll just leave it at that. Are there ongoing fees for trust administration? Well, if you set up, it's a question we get all the time. If you set up your revocable living trust, transfer title of your assets to your trust, you're the trustee. So no, there's going to be no ongoing issues, costs or expenses, no monthly, no annual. You're just titling things from Fred Flintstone to Fred Flintstone as trustee of the Fred Flintstone Trust. And there's no ongoing expenses for that. There's no ongoing fees. There's no bank fees. There's no brokerage firm fees other than the fees that an individual who would have that same account would incur. So no ongoing expenses for the revocable trust. Now, if you have a corporate trustee, oftentimes grandpa might say, when I die, I leave X dollars to my children, to my grandchildren in a trust. I name Vanguard, Schwab, Fidelity, their trust company as the trustee. Yes, corporate trustees charge corporate trustee fees. Each one has their own fee schedule. You can look at it online. When can you change a trust? Well, going back to the revocable and irrevocable, a revocable trust, again, the most common type is that trust to avoid probate. It's a revocable within our trust. You can change it. You can change any of it anytime. You can do trust amendments. You can restate the whole trust. You can cancel the whole trust, revoke the whole trust, put everything back in your name if you want to. Don't see that happen very often. But those revocable trusts, you reserve the right to change it. If it's an irrevocable trust, can you change it? Got to look to the terms of the trust. An irrevocable trust means it's irrevocable. It can't be changed. Although in some irrevocable trusts, the person who created the trust reserves the right to change certain things. So it might say, I'm setting up this trust for my grandson. I'm naming my son as the trustee, but I reserve the right in the trust to change who the trustee is, but I'll never be the trustee. It might say something like that. So you have to look to see if there's any flexibility within that irrevocable trust to change things. Common myths and misunderstandings about trusts. I think the biggest one is people think trusts are only for the wealthy. I tend to think the middle class can gain more, not more, but can benefit just as much from using trusts as the super wealthy folks to avoid, probate. If there's a $20,000 or $30,000 probate expense that can be avoided, well, a $20,000 or $30,000 expense that eats into an $800,000 estate takes a significant portion of that estate. $50,000 probate on a $7 million estate. $7 million estate can absorb that. But trusts are not only for the wealthy. A lot of misconceptions about the tax issues. Most people think that all trust income is taxed at the confiscatory trust income tax rates, whereas in many, many, many cases, trust income gets taxed to individuals, and the tough trust income tax rates gets avoided. All right. Next, some practical scenarios. And I've really talked about all these. It's the revocable living trust to avoid probate. It's the person with the $15 million estate who wants to, because they have a bunch of children and grandchildren and great-grandchildren, they want to set up gifting trusts to gift assets to those children, grandchildren, and great-grandchildren to get those assets out of their estate and avoid the 40% estate tax. There's the parent who has a child with special needs and because due to their special needs, that child is getting certain government benefits. So we haven't talked about this, but the parent often in their estate planning documents, will or living trust, they'll set up a special needs trust for the benefit of that child so that assets can be left for the benefit of the child, but in a way that they don't cause the child to lose their government benefits. Our typical example, again, another scenario, grandpa wants to leave money to grandchildren, a grandchild or grandchildren, but he doesn't want to dump it in their lap, so he sets up a trust for them. The blended family situation is really common where, let's say, a husband, he has 3 children from his first marriage, he gets married later in life. He wants to provide both for his new wife who has children of her own, but he doesn't want leaving things to his wife to cause his wife to leave those things to her children. He wants to protect his own children. So he'll leave assets into a trust for his wife and provide how she could take distributions from that trust for certain purposes. And then when the wife later dies, because those assets are in a trust and because the husband set it up this way, those trust assets, when the wife later dies, his surviving wife who has children of her own, the husband sets it up so that when his surviving wife later dies, those trust assets revert back to his children. Really, really common there. All right. So those are both some kind of scenarios and some case studies and some examples. I think I've hit all the key points and all the popular scenarios, why people create trusts, avoid probate, trust for spouse, like I just said, for minors or young people, in order to qualify for long-term care Medicaid, gifting assets to get assets out of the estate. And then some parents leave assets to their children or grandchildren in a trust to get that divorce-proof protection. All right, moving on here. Let's see what we've got. We got all the usual hellos. Good to see everybody. Ray's here. Good to see Ray. That's a name I recognize. Kathy joining late. Fantastic. Michael, tax implication. Okay, we talked about that, Michael. The trust income is either going to be taxed to individuals and just made part of their taxable income to be taxed at their ordinary income rate, or if a trust accumulates income in certain circumstances, then the trust pays income tax, typically at higher trust income tax rates. So we often try to set all these arrangements up so that the trust never has to pay income tax at the higher trust income tax rates. You're welcome, Julia. David, awesome. I've been wondering about trust late and how time. Good. Timing is everything. Dorothy, what if there's a mortgage on home? Can you? Yeah. So we have some federal laws. I think it's called the Garman-St. Germain Act, an act Congress passed many years ago, which says you can put your home into a trust. And it's typically, we get that question when people put their home into a revocable living trust. But the Garman-St. Germain Act, you can look it up, says that, if you put your home into a trust and you're the beneficiary of that trust, which you are if it's a revocable living trust, it doesn't trigger the due on sale clause. So you don't have to go refinance, get a new loan, nothing like that. Good question there, Dorothy. M. Cigarito, are taxes due on dividend earnings if the estate has not been distributed? Yeah. So I think in this interim period, are kind of in the estate, I think is what you're asking. Yeah. You pass away, you own stock, that stock produces dividends. During that time from the time you die until those assets, because probate may take a year or two or whatever, before that stock gets distributed to the heirs, then the estate owns the stock. The dividends are taxable income of the estate. And as I referred to these income tax rates where they have to pay tax at 37% on trust income that exceeds $15,200, it's the same for estates that have income. So to the extent that the estate has income that exceeds $15,200, then in a calendar year, then the estate has to pay income tax at that highest 37%. So yeah, you don't just get to avoid the tax by leaving the income producing asset in the estate. Good question though. Estella Pebbles has her trust. If she pulls money from the trust to later commingle with her husband and buys a second, would that not allow? Yeah. So if she takes money out of her trust, goes and commingles it with other assets that she has with her husband, then yeah, it's likely, she loses half of it if she gets divorced. So the idea is keep it in her trust. And And maybe if she wants to buy a home, maybe have her trust buy her home. And that's, again, a trust asset. It's just hers and hers only. But if she takes a distribution from the trust and then she and her spouse go, buy stuff together jointly, and it loses that separate status. Linda, in the event of incapacity with a regular trust, with a corporate trustee, how does the bill paying from the trust work? So let's say Fred Flintstone has his revocable living trust, and the trust says if Fred ever dies or becomes incapacitated, then Vanguard National Trust Company becomes the trustee. If Vanguard is willing to accept the position as trustee, and they are, if the assets are significant enough, because they can charge their corporate trustees. No offense there, they all do it. Then the corporate trustee takes over the accounts and they pay the bills, and that's what corporate trustees do, is manage the assets of a trust and make sure bills get paid. So they would do that. Wilma is now 96. Fred died. What to do? Community Medicaid. So Stevie only, not sure what you're asking. Fred died. Depends on what assets Wilma has, and that you put the word Medicaid ? So that all depends on the assets of Wilma. We'd have to look at all that. Estella, could you be able to help with the trust established in Canada? Canada's a trustee and the trustees have not followed the will. If everybody's in Canada, probably not. Larry, you have done some state-specific estate planning discussions covering differences and how they might be unique. Can you see? I do. I just need to find a really good California attorney and we can have a discussion about that. And I know a bunch. We've got South Carolina tomorrow. I'm excited about that one. We've got a couple of more on schedule. Don't have California, but my goal is to, have some good state-specific discussions from attorneys in different states, so we can touch on the various state-specific issues. Steve only, revocable trust in place, trying to maximize interest rates on savings, but Wilma cannot make it to the bank to set up account with what to do. Well, it depends on why Wilma can't make it to the bank. Is she incapacitated? My guess is Fred and Wilma are initial co-trustees. Trust probably says if one of them can't be the trustee, the other one becomes the trustee. So then it would be documenting for the bank some type of resignation or something like that. You're welcome, Larry. Okay, so you just have to deal with the bank, see what they require. Every bank has its own rules. I would say it's not easy working with banks and all that. So good one here on trust. I know I went fast, went through a lot of stuff. That's just my style. And so we've got a bunch of live streams upcoming. You can check the channel, check the schedule, starting tomorrow with South Carolina. We'll see you next time.